How concerned should we be every day about being sued?
Because you don't want to take a misstep that could
Yeah,
complicate things further. And the
yeah.
next day you're thinking about it and you go back and look and say, boy, I wish I'd said such and such.
Are you a PA or an NP who has been named in a lawsuit and you really don't know what's going to happen next? Or are you a PA or an NP who's never been sued, but you're kind of living in fear of being sued? Well, in my interview today is actually the second part of an interview I did with an attorney, a malpractice attorney, who actually also used to practice as a PA and is still a licensed PA. I'm going to ask him, like, what happens when you get sued? What can you do? What should you do? What shouldn't you do? Should you have your own attorney, or are the employer's attorney going to fight for you? And who gets to decide if the case is going to be settled or go to court? I'm going to address those questions and more with him. So if you are a practicing PA or NP, I urge you to continue to watch this video so you understand and get a little peace of mind about what happens in a malpractice lawsuit. Hi, it's Michelle with the Medicine Couch. Thank you so much for joining me today. And if you think that this video could help a colleague of yours, please share it with them. Now let's dive in and learn about what happens in a malpractice lawsuit.
Hi, I'm Peter Bergé. I've been a PA since 1982 and an attorney since 2004. I spent 12 years as a litigator in a boutique law firm with a concentration in medical malpractice. These days, I work as a medical legal consultant and educator.
How concerned should we be every day about being sued? Because I have a good friend who that is on the top of his mind all the time. Even though he's an excellent provider, he's always afraid he's going to do something and get sued. Do you have any thoughts on that? Is it something we should really be worried about all the time?
I have lots of thoughts on that. First of all, no, you shouldn't be worried about it all the time or even worried about it much because that's counterproductive. That's why we have insurance. And if you're sued, you notify your employer, your carrier, they assign an attorney to you and they will take care of it. And yes, it's stressful. I've never been sued as a PA. I was sued once as an attorney. And yes, it's stressful, but it's not the end of the world. You don't wind up spending a whole lot of time on that. But no, that's why you have insurance. And also, unless it's a question of gross negligence or negligent homicide or something like that, the chances of your losing your license over your standard run-of-the-mill malpractice is extremely low.
Okay.
Extremely low. And so people talk about, oh, well, it's my license. I'm like, yeah, unless you're diverting narcotics or it really in the whole controlled substances area or commit fraud
Yeah.
or something along those lines, the chances of your license being involved are very low. In New Jersey, there's a malpractice database for physicians, and we routinely looked at those. It only goes back there 5 years. And I saw some with 4, 5, 6, even 7 large payments made on their behalf. And
Wow.
they're just trucking along, practicing or malpracticing. In 12 years of litigation, I only had one licensing board ever contact me. And it wasn't a PA or physician, it was a respiratory therapy licensing board. But in any case, no, I don't think one should be worrying. That doesn't
Okay.
do good things for your stress hormones
Yeah.
and it doesn't help. On the other hand, I give a lot of classes and courses and talks about what's called defensive medicine, and particularly around communication in medical practice. And you can and should incorporate what is risk reduction and good care.
Yeah.
And those two go hand in hand. So if you're communicating well and ideally very well with your patients, if you're documenting that you're doing that, if you're communicating well with the rest of the healthcare team and anybody else who's involved in or may become involved in a patient's care, which includes charting and includes, for instance, if you're a radiologist, notifying making sure that somebody's aware that a particular finding is consistent with malignancy and that sort of thing. If there's good communication and if there's good documentation of that communication, if you're following a good standard of care, then you are actively reducing your risk and you're practicing well or better. So you should think about, when you write a note or dictate, how that's going to look blown up in a screen in front of a jury. And so if you're trashing the patient, patient's non-compliant, patient's this, patient that, how's that going to come off in front of the jury? Are you going to be a sympathetic professional, or are you going to be a patient basher? Because what a jury thinks of you can influence a case as much and sometimes more than the facts of the case. And so if you look like a jerk on paper, they may want to give the verdict. If it could go either way, they're going to give the verdict to the patient. So you can reduce your risk both of being sued and, if you are sued, of losing by being a good practitioner, by charting well, by communicating well, and use the energy for those efforts and not for worry. To be clear, that doesn't mean ordering all sorts of extra tests, but sometimes thinking about that and thinking about how it'll look afterward, sometimes that'll mean that you order a test that you should have, or at least you're giving the patient the benefit of the doubt. But you don't want to be ordering it just defensively if it shouldn't be ordered. And I'll give you a concrete example. Our firm had a case where an ER doc ordered a CT scan with contrast that wasn't indicated. Neither the contrast nor the CT scan, and the patient had an anaphylactic reaction. And we got at trial, we got a judgment in that case. So ordering unnecessary tests isn't necessarily protecting yourself. In this case, it injured the patient significantly. It also helped a lot that both the defendant and their primary expert were jerks. And so that helped with the case a lot. But ordering extra tests or procedures doesn't necessarily protect you. The question is it indicated? If you do it, say why. If you didn't do it, say why, so that your clinical reasoning is evident, because you may not remember. That's the way you can reduce your risk and hopefully reduce the amount that you worry and provide excellent care.
Yeah, excellent points. So I saw somebody had posted recently that they received a letter or some kind of communication from their medical board asking them for some documentation about this patient because there's been a complaint filed against them. So not a lawsuit yet, but just a complaint filed with the medical board. If you get something like that, is your advice that you should right away get an attorney or somebody else involved? Okay. So blanket across the board, you should never give information to anyone unless you know that you have some attorney that you are speaking with, either your employer's attorney or your own attorney giving you advice on what to give in.
That's not what I said.
Oh, sorry.
under those specific facts, if it were me, I would consult an attorney who has a significant practice in representation before licensing boards. There are lots of other situations where it's not necessary, but I would certainly consult an attorney under those circumstances, because you don't want to take a misstep that could complicate things further. I think it's going to be it's probably going to cost you a couple of grand anyway in terms of a retainer, but I think it's worthwhile in terms of your peace of mind.
Okay. Well, what about if you got a letter saying that you are being asked to be deposed from an attorney in this malpractice suit, and that's the first you've heard of it? I've seen people saying like they're just getting stuff. They don't know if it's a scam or if it's real. They don't know what the next steps are. So what would you advise people if they receive something and it's not direct communication from their employer or the employer's attorney? How do they go about verifying that this is real and what they need to do?
Sure. First, we want to look at the facts. We want to look at the details. They say the devil's in the details. If they just get a letter from a law firm saying, we'd like to take your deposition regarding this patient and their care during this time, I would call them up and ask, what kind of lawsuit is this? If they say it's a personal injury suit where they were in an accident, something happened, you were taking care of them, and we want to verify some things from the record, That's a very different circumstance from a malpractice suit. Right. So those are two very different situations, and a lot of colleagues sort of panic, and a lot of others give them this, oh, don't say anything, or just tell them you don't remember anything, and tell them the record speaks for itself. And as an attorney, I don't agree with that, because there are lots of reasonable questions that they could and sometimes should ask, and you're both, in theory at least, wanting to help the patient, right? This is your patient. The patient's been injured. They're trying to recover compensation from somebody who's being accused of injuring them. Why would you not try to do your best to help them by providing all the facts that they need? People will ask, well, they have the record in front of them. You probably don't even remember anything. And what if you misspeak? Well, the attorney may be trying to establish what the patient's functional status was before the accident. And you happen to see them for something unrelated a month before the accident. And it says cranial nerves 3 through 12 intact to screen. So they may say, well, okay, what's your exam that you normally do in order to chart that? Well, I'm looking at their eyes. I'm looking at their faces. I'm looking at I may not have them actually smile, but I can see their facial expression. And so I'm observing a number of things, and then maybe I did this and that. Fine. So they can then, if necessary, go to court, or at least in their negotiations with the insurance company, say, look, they didn't have one eye going that way a month before. They do now. All right. So that's a very reasonable question. It's something that we as clinicians can testify to. It doesn't put us in any danger, and we're helping our patient. So, I strongly disagree with my PA colleagues who adamantly say, oh, well, don't say anything, because you're not the defendant. Right. You've already established that, they're suing whoever it was that left the floor wet, cracked their melon on the floor because they stepped in the soap, and you're not in danger. Help your patient.
Don't panic if you've been contacted about something. Find out what the details are first, and then you can, if necessary, make sure that you have the appropriate attorneys involved for you.
Right. I mean, if there's a question, if there's a malpractice question, even if you're not named in the suit, then you give your carrier a call and say, this is the situation. Do I need counsel? And if so, send them.
Okay. Yeah, so we shouldn't be afraid to reach out to our carrier to ask questions when we have something. I think it seems like a weird thing.
Yeah. It's very different if a process server comes to your house or your office and hands you a document that says you're being sued, or you get a certified letter to that effect. That's a whole different situation.
Say you get notice, you've been served, you're going to get sued. I think our first instinct, everybody wants to look at the chart and look this patient up, because most of the time we don't remember, or we may not remember all the things. We just want to see, what were they in for? What, did we double check ourselves, make sure we feel comfortable with what we put? Is that a big no-no? Is that problematic if you do that?
My first question would be, where are you working? Because a hospital may have a policy about that.
Oh, okay.
And so if you're working in a hospital, I would talk to risk management before doing that and follow their guidance. It was easier in the past when it was all on paper, and there was nothing wrong with it. And in depositions, we would ask, from the time that you became aware of this lawsuit, when was the first time after that you looked at the patient's record? And it's not uncommon. No, as soon as I found out, I was.
Yeah.
That's all right. I mean, as you say, that's a perfectly normal response. But if you work at an institution or a large practice, or a practice that's owned by an institution, which many people do now, you want to start with risk management and find out if you can do that. And you could even say, I want to look at the chart. How do I do that? But follow their guidance. If you're working in a private practice, you can probably do it. But even so, you're probably better off. You're going to be talking to your carrier, right? And you're probably better off saying, when can I look at the chart?
And I assume that looking at it, as long as you know that you're fine in your institution, is one thing, but you certainly should never try to go in and clean up the chart or add anything or change it in any way, correct?
Correct.
Okay. because all of that can be tracked and it's time stamped and they know when things were done, and attorneys will have all of that, right? And it'll look like you're trying to falsify or change things if you mess with it at all, right?
However, say you had a situation and you have a bad feeling about it afterward. You go back and you look and you feel like you left something out, let's just say.
You mean like just after a visit, not after you've been sued, just
Right,
after
or a
a visit and
code
stuff.
or
Yeah.
whatever, and the
Yeah.
next day you're thinking about anything and you go back and look and say, boy, I wish I'd said such and such. You can put a post note, even though it's showing up in the EHR for when it is. I would still date it, say post note, such and such date, blah, blah, blah. Last night, blah, 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 this and that happened. You don't have to necessarily say, I forgot that. And it's certainly reasonable, as long as you're telling the truth and not doing it in a sneaky way. And I think in the end, if there were a lawsuit, your own attorney could give you a chance to explain that. Well, why did you write that? Why wouldn't I? I was, my patient got sicker. I was worried about my patient. And of course, I went back over everything in my head and I wanted to be sure that this was in the record.
Yeah, I think along those lines, I think we're kind of paranoid because we think any tiny little mistake or a thing we do not 100% perfect is going to be used against us. But I get the sense in talking to you that as a bad rap as attorneys get, most of the time, that's not what they're trying to do, is trap you in some tiny detail. They're looking to see, did you practice malpractice? Did you do something grossly wrong against the standards? Is that fair to say in general? I'm not saying that there wouldn't be.
The plaintiff's attorney is going to do their best to represent their client. And they wouldn't have taken the case if they didn't believe that, say, your negligence or your colleagues or coworkers' negligence injured their client. And in most situations, they wouldn't be there unless they had an expert also telling them that. So that being said, if they already think and believe that you were negligent, they potentially are going to look at every little thing and bring that up if it's necessary. And sometimes that even comes up in terms of contradicting what their expert says.
And so if you're leaving a job, or say you've left a job 3 weeks ago, and then all of a sudden a lawsuit now has been brought against you. And I know that we talked about this in the first part, we talked about malpractice, but for people watching this video, is the employer, are their attorneys still obligated to, as long as you're covered under tail, or if it was an occurrence, still obligated to work just as hard for your defense as they would if you were still a current employee?
Well, irrespective of the insurance issue, you are an employee, so your employer is vicariously liable under what the doctrine that's called respondeat superior, which is actually the master-servant relationship, but they're liable for your negligence. It's a dead language, and some of the concepts are outmoded.
Yeah, but still, that's funny.
Right. It actually means that the master responds for the servant. You are also liable, so don't think you get off scot-free. But no, their liability for what you did while you were working for them doesn't end because you left. And so they need to defend themselves by defending you, and likewise their insurance.
Okay, so if you're being sued, named in a lawsuit, and your employer has the attorneys, working to defend you and the employer themselves, if they want to settle, but you feel strongly that you don't want to settle and that you want to go to court, can you demand that, or are the insurance carrier and the attorneys going to mandate whether you settle or not?
The default is that the insurance carrier makes the ultimate decision. The attorney never does. It's always the client's decision. The tricky part here is that the attorney has two clients. Right? The attorney has the insurance company who is paying that attorney or that law firm, and also has the insureds as clients. And so they have kind of split loyalties. Typically, in general, in terms of insurance for negligence, the insured does not have the right to give consent or not give consent. The major exception is physicians. In some states and under some policies, they give the physician the right to consent or not consent. Even so, if they really need to, sometimes there are ways that the insurance company can sort of turn the screws and pressure them to consent, because they know they can probably do better in settlement than at trial in certain cases, and they can pressure them. And there are situations in which attorneys can pressure a plaintiff to settle a case, even if the plaintiff wants to go to trial and the attorney has a good idea that the trial is not going to go well. But in general, it's the insurance company. This goes for auto accidents. Auto accidents, you have nothing to say about it. And in most malpractice cases, unless the policy has a specific clause giving you the right to consent or to withhold consent, the insurance company is going to make that decision.
If you're getting sued and you're having to go in and do depositions, or when it comes to court time and you have to be away from your practice, and say you work on like RVUs or you're being paid hourly and you're not there, defendants get any kind of compensation for time lost?
Certainly in New Jersey, they get nothing. I don't know if there's any state that provides anything. I would be very surprised if it did, because you're a party to the lawsuit. You need to show up or you'll be sanctioned one way or another. However, if you're a fact witness in a lawsuit, say you treated the patient at some point, there are often provisions under state law or under the state rules of court or rules of civil procedure for witness remuneration for your time. And also informally, it's not unusual that if you ask the attorney for either travel expenses or some sort of hourly fee or both, they will often cover that, even if they're not necessarily required to. Now, in my opinion, if it's not costing you anything, in other words, if you're on salary and your employer says go and they keep paying you, I don't think it's ethical to ask for something on top of that, because you're being paid for your time. Right. As you say, if you're losing RVUs, certainly if you're being asked to use paid time off, that's a different issue.
Just any last tips that you would tell people for navigating through a lawsuit if they get named?
Yeah, if you have a personal policy or if it's a private practice, I would contact the carrier directly and also the practice manager. I always advise starting a log of everything that you do. In other words, when you spoke to the carrier, what time, etc. If they asked you to email something or fax something, what you did, when you did, who you talked with at the practice, etc. And just keeping a little log in case a question comes up. I wouldn't expect any plaintiff's attorney to contact you or a plaintiff, but if so, refer them to your carrier or your attorney. And what's going to happen is your carrier is going to assign an attorney to you. Usually it's an outside firm. Occasionally, some hospitals are self-insured and they will use in-house counsel, and they will contact you and take you through the process. Remember that you are one of the clients, in addition to your employer and in addition to the insurance carrier. You're one of the that attorney's clients, and so don't hesitate to ask them things, have any ambiguities cleared up, have them tell you what the next steps are and what the schedule is, etc., because you should be able to have those questions answered.
Okay, great. Well, I know that you have so much information that you can share with people, and I know you do a lot of educating. You like to speak at conferences, and if there's groups that looking for an educator to talk to their providers about the whole malpractice gambit, I guess, then you are available for that, right? And we'll put your email down below that people can contact you there.
Absolutely. Yeah, I love to give talks with PA and NP colleagues, with PA students, with doctoral students. And so, yeah, I'm happy to hear from you if you like some sort of educational assistance.
Well, thank you so much, Peter. This has been great. And I love that you are allowing us to pick your brain.
My pleasure.
Well, the video you just watched is actually part 2 of the interview I did with Peter. In the first part of the interview, we discussed malpractice insurance, all the different kinds, things that you need to make sure are correct on your certificate, and how and when you purchase tail and nose insurance and all those good things. So if you're interested in finding out and making sure that you are protected to begin with, then make sure you watch this video here. Thank you so much for joining me today. And as always, take care, stay sane, and I'll see you next time on the Medicine Couch. Bye.